Oi, som. Oi. Senhoras e senhores, boa noite. É com grande satisfação que iniciamos, neste momento, a mesa de abertura da palestra do Juiz da Corte Internacional de Justiça, Iwasawa Yuji. O evento é uma realização da coordenação do curso de Direito e da Clínica de Direitos Humanos e Direito Ambiental da Escola de Direito da Universidade do Estado do Amazonas, com o apoio da Agência de Cooperação Internacional do Japão e da Cátedra Fujita Ninomiya, da Universidade de São Paulo. O juiz Yuji Iwasawa, da Corte Internacional de Justiça, estará no Brasil até o dia 29 de outubro. A visita é organizada pela Cátedra Fujita Ninomiya, cujo objetivo é a realização da palestra especial Enforcement of International Law em diversas universidades, por intermédio das cátedras da Agência de Cooperação Internacional do Japão. A cátedra é parte integrante do Programa de Estudo do Desenvolvimento Japonês. Esse programa, por sua vez, é um projeto do governo do Japão, instituído na ocasião da celebração dos 150 anos da restauração Meiji, e visa desenvolver a pesquisa e o estudo sobre a experiência da modernização japonesa, de modo a fomentar a formação de recursos humanos e difundir o processo de modernização do Japão em outros países, sempre respeitando a identidade e a história de cada país. Para compor a mesa de honra desta cerimônia, anunciamos o coordenador de qualidade de ensino, professor mestre Newton Alves, neste ato representante do governador do estado do Amazonas, Wilson Miranda Lima, e da reitoria da UEA. O cônsul-geral do Japão em Manaus, senhor Masahiro Odino. O professor doutor da Universidade de São Paulo e presidente da Cátedra Fujita Ninomiya, senhor Masato Ninomiya. O coordenador do curso de Direito da Escola de Direito da Universidade do Estado do Amazonas, professor doutor Ricardo Tavares Albuquerque. A coordenadora da Clínica de Direitos Humanos e Direito Ambiental, professora doutora Silvia Maria da Silveira Loureiro. Registramos e agradecemos a presença da juíza federal, diretora do Foro da Justiça Federal do Amazonas, Mara Elisa Andrade, da cônsul-geral adjunta, senhora Reiko Nakamura, do corregedor-geral e secretário adjunto da OAB, doutor Henrique Morelli de Sá Nogueira, do presidente da Comissão de Relações Internacionais da OAB, doutor Elcio do Carmo Ribeiro, do coronel Sato do Exército, ADESG, do delegado Mário de Queiroz Pierre Filho, ADESG, o senhor Rodrigo Fuji, convidado do Consulado do Japão. Para realizarem suas considerações acerca do evento, passamos a palavra para a coordenadora da Clínica de Direitos Humanos e Direito Ambiental, professora doutora Silvia Maria da Silveira Loureiro.
Boa noite, senhoras e senhores. É uma grande honra para a Escola de Direito da Universidade do Estado do Amazonas e para a Clínica de Direitos Humanos e Direito Ambiental da Escola de Direito da Universidade do Estado do Amazonas receber, na noite de hoje, o juiz Yuji Iwasawa, da Corte Internacional de Justiça. Gostaria de agradecer particularmente ao esforço do professor Masato em ter colocado a palestra do ilustre juiz Iwasawa no roteiro do Estado do Amazonas e também a JAICA pelo financiamento desse importante evento no nosso país. Senhor juiz Yuji Iwasawa, para nós é uma grande honra recebê-lo aqui, pois ter conosco alguém que tenha trilhado a carreira acadêmica e a magistratura internacional em um curso como o nosso, que preza pelos valores do direito internacional e pela construção de uma cultura de paz, é muito importante para que nossos alunos conheçam na prática o direito internacional. E para nós é particularmente grato ter também uma pessoa que tenha tido convívio com o nosso saudoso juiz Antônio Augusto Cansado Trindade, que é sempre um guia e um mestre, e tanto deixou como legado para nossas futuras gerações. Então, em nome da nossa Clínica de Direitos Humanos e Direito Ambiental, guiada pelo legado do professor Antônio Augusto Cansado Trindade, gostaria de lhes dar as mais cordiais boas-vindas. Muito obrigada.
Passamos a palavra ao coordenador do curso de Direito da Escola de Direito da Universidade do Estado do Amazonas, professor doutor Ricardo Tavares Albuquerque.
Boa noite a todos, boa noite a todas. É realmente uma grande honra estarmos aqui nessa noite, recebendo o juiz da Corte Internacional de Justiça, Iwasawa Yuji. Queria também agradecer a presença nessa mesa do consulado, do cônsul-geral do Japão em Manaus, cônsul-geral Masahiro Ogino. Muito obrigado pela sua presença. Queria também agradecer a presença nessa mesa do professor doutor da Universidade de São Paulo e presidente da cátedra Fujita Ninomiya, senhor Masato Ninomiya. Muito obrigado pela sua presença na data de hoje. Queria também agradecer ao professor Newton, que está aqui, representando o nosso diretor da Escola de Direito. E, por último, agradecer, enquanto coordenador do curso de Direito, que, com grande honra em poder ter uma professora como a professora Silvia, de realizar um evento desse. A professora Silva está aí há um mês lutando, fazendo de tudo para trazer para os nossos alunos, para nossas alunas, o nosso querido juiz da Corte Internacional de Justiça, poder ter essa honra, enquanto universidade na Amazônia, de ter uma palestra como essa. Então, professora Silva, em nome dos docentes, em nome dos discentes, em nome de toda a Escola de Direito, agradecemos muito por esse evento. E queria também falar, que é algo importante, neste momento de que a paz internacional está abalada, de termos uma palestra falar sobre a aplicação do direito internacional. E termos aqui a honra, novamente, de receber o juiz Iwasawa Yuji, porque a nossa escola de direito, capitaneado pela professora Silvia, é uma escola de direito que realmente sempre ensinou, sempre esteve presente nas questões de direito internacional, competições perante nós somos poucas escolas de direito no Brasil que têm uma atuação internacional perante a Comissão Interamericana de Direitos Humanos. Então, na data de hoje, representando o curso, eu fico muito honrado, eu fico muito feliz e queria realmente desejar a todos uma excelente palestra e que realmente, meu desejo na noite de hoje, que é um desejo voltado, sim, para a paz internacional e para o cumprimento do mais belo dos direitos, que é o direito internacional. Muito obrigado.
Passamos a palavra ao professor doutor Masato Ninomiya.
Boa noite. Grande prazer voltar a Manaus. Estive aqui pela primeira vez em 1966, antes da Zona Franca. A cidade de Manaus ainda era uma cidade muito pacata, triste. Não havia luzes na rua, não havia ar-condicionado nas casas. A geladeira era com gelo comprado aí na fábrica de gelo aí no Rio Negro. Depois voltei em 68, já a cidade totalmente mudada, muito ativa, graças à Zona Franca. E depois concluí o curso de Direito na USP, fui estudar no Japão, 10 anos de curso, mestrado e doutorado na Universidade de Tóquio, voltei, prestei concurso na USP e passei a dar aula na USP em 1986. 37 anos de magistratura magistratura, não, de magistério na Faculdade de Direito da USP, e eu estou me aposentando no próximo mês, compulsoriamente. Mas vou continuar vão me dar o título de professor sênior, e perguntei para que servia esse título. Aí disseram, para o senhor continuar trabalhando de graça para nós. Mas vou continuar assim como muitos professores da Faculdade de Direito da USP, já há muito tempo aposentados, mas continuam dando aula, muitos na pós-graduação, orientando, não é? E agora, graças à criação dessa cátedra Fujita Ninomiya, pela JAICA, então, mais uma razão para eu continuar lecionando na Faculdade de Direito. O nome da cátedra Fujita se deve ao embaixador Edmundo Fujita, cuja biografia acabei de entregar para a professora Silvia, quem tiver interesse poderá ler. Trata-se da biografia do primeiro descendente de japonês a ingressar no Itamaraty. Foi meu colega na Faculdade de Direito. Na verdade, eu sou um ano mais, quer dizer, eu sou veterano, ele foi meu calouro, mas estudamos junto no Japão, e ele interrompeu o estudo, apenas 2 anos no Japão, e voltou e prestou concurso no Itamaraty. Falava-se na época que japonês não entrava no Itamaraty. O Fujita tirou o primeiro lugar no concurso do Instituto Rio Branco. Medalha Lafayette Silva, dada ao primeiro lugar. Então, o ingresso dele no Itamaraty foi em conteste. Foi embaixador do Brasil na Indonésia, na Coreia, e esperava-se que ele seria o próximo embaixador do Brasil no Japão, mas, infelizmente, a doença o tirou-nos da nossa companhia. Faleceu em 2016 e está sendo homenageado. Tem uma unidade básica de saúde em São Paulo com seu nome, tem uma rua, um logradouro com seu nome dele, e essa cátedra Fujita, porque o orientador dele, o tutor dele na Universidade de Tóquio, se tornou presidente da JAICA, Sr. Kitaoka, então ele quis homenageá-lo com esse nome. E aí a cátedra ficou com o Fujita Ninomiya também, graças à boa intenção dele, disse que eu também merecia homenagem. Eu imediatamente recusei, dizendo que eu ainda estava vivo, mas aí ele insistiu e acabei aceitando. Aceitei, naturalmente eu não me arrependo, mas o Fujita está morto, então é só um tipo de homenagem. Agora eu tenho que trabalhar, continuar trabalhando, e tenho levado essa cátedra para diversos lugares, né? Existe uma cátedra semelhante na Universidade Estadual do Rio de Janeiro e também na UNB. E agora eu quis mostrar ao meu colega, Yuji Iwasawa, que também foi meu colega na Universidade de Tóquio, estudamos juntos, mas eu quis mostrar para ele a Amazônia, porque a maioria dos japoneses que vem para cá só conhece São Paulo, Rio e Brasília. Eu falei, olha, tem que conhecer a Amazônia para conhecer o Brasil. Inclusive, falei para ele, tem muita água lá. Só que tivemos um pouco de azar, né? Ontem fizemos, entretanto, um passeio de barco, e eles ficaram impressionadíssimos com a quantidade de água, né? Que está um pouco mais baixo. Mas, enfim, esse foi o propósito que me trouxe novamente aqui à Amazônia. Tenho muitos amigos, né? E aí o juiz Iwasawa, a esposa dele, impressionados com a Amazônia. Espero que eles levem boas impressões, incluindo as impressões aqui da Faculdade de Direito da Universidade Estadual de Amazonas. Muito obrigado pela atenção.
Passamos a palavra para o cônsul-geral do Japão em Manaus, senhor Masahiro Ojino.
Coordenador de Qualidade de Ensino, professor mestre Newton Alves. Iniciado representando a direção da Escola de Direito, professor doutor da Universidade de São Paulo e presidente da Cátedra Fujita Ninomiya, professor Dr. Masato Ninomiya, e coordenador do curso de diretora da Escola de Diretora da Universidade do Estado do Amazonas, professor Dr. Ricardo Tavares, a coordenadora da Clínica de Diretores Humanos e Direitos Ambiental, professora doutora Silvia Maria da Silveira Loureiro. Distinguidos convidados e alunos, todos os presentes, boa noite. Minasan konbanwa. Sinto-me muito alegre em poder assistir a esta maravilhosa palestra do excelentíssimo senhor Yuji Iwasawa, juiz da Corte Internacional de Justiça. Gostaria de agradecer a esta preciosa Universidade do Estado de Amazonas por sua colaboração para realizar este evento. O Japão e o Brasil são parceiros estratégicos na comunidade internacional, compartilhando valores fundamentais como a democracia, os direitos humanos básicos, a economia do livre mercado, o Estado de Direito, entre outros. Hoje, nossos países também cooperam entre si como membro do Conselho de Segurança da ONU. Por isso, espero que ambos os povos, especialmente os jovens, conheçam cada vez mais uns aos outros. Com isso em mente, o programa de estudos sobre desenvolvimento do Japão, chamado de Cátedra Fujita Ninomiya, em homenagem aos dois grandes nomes Nikkeis no Brasil, foi criado na Universidade de São Paulo em 2018. Acabamos de ouvir a grandiosa realização do excelentíssimo senhor embaixador Eduardo Susumu Fujita, e também aqui está Dr. Masato Ninomiya, está presente esta noite. Ouvi dizer que não há ninguém nas relações Japão-Brasil que não tenha ficado em dívida com o Dr. Ninomiya. Pessoalmente, eu também tenho mantido contato com ele desde minha chegada a Manaus há mais de 2 anos para solicitar ele que me ensine sobre o Brasil. Já acabamos de ouvir a apresentação do excelentíssimo senhor Yuji Iwasawa, mas gostaria de enfatizar que o juiz Iwasawa é um dos proeminentes de sabedoria do Japão e é uma autoridade mundial na área de direito internacional. Diante da invasão da Rússia na Ucrânia e da atual situação entre Israel e a Palestina, consideramos uma vez mais a importância do Estado de Direito e do direito internacional. Na reunião entre o presidente Lula e o primeiro-ministro japonês Kishida em Hiroshima em maio, concordaram em cooperar para manter e fortalecer a ordem internacional baseada no Estado de Direito. Neste sentido, acredito que o evento desta noite é muito oportuno. Quero agradecer a JICA que sua apresentação, senhor Kataoka, está aí, e também, uma vez mais, ao juiz excelentíssimo senhor Yuji Iwasawa. Senhoras e senhores, Manaus é uma cidade especial para o Japão. Atualmente, esta linda cidade tem apenas 3 consulados gerais: Colômbia, Peru e Japão. Então, exceto em esses países vizinhos, o Japão é o único país a ter um consulado geral em Manaus, porque esta cidade tem a maior comunidade Nikkei desta região amazônica ocidental, que consta aproximadamente 30 mil pessoas. Além disso, mais de 40 empresas japonesas estão atuando na Zona Franca de Manaus. Gostaria de agradecer ao Estado do Amazonas para aceitar com simpatia estes Nikkeis e empresas japonesas. Por mais de 90 anos, nós japoneses contribuímos para o desenvolvimento desta terra e continuaremos a colaborar com esta região, que agora é o foco do mundo, e a trabalhar juntos, já como parte desta preciosa região amazônica. Como cônsul-geral do Japão, estou muito satisfeito em celebrar esta magnífica palestra do Juiz Iwasawa em Manaus, especialmente nesta universidade, que vários formados já fizeram seus estudos no Japão através das bolsas que o meu consulado oferece. Desejo que, por meio deste evento, vocês tenham mais interesse na comunidade internacional e assim contribuir com os laços de amizade entre o Japão e o Brasil. Muito obrigado.
Neste momento, passamos a palavra ao coordenador de qualidade de ensino e, neste ato, representante do governador do Estado do Amazonas e da reitoria da UEA, professor mestre Newton Alves.
Meu boa noite aos prezados alunos, prezadas alunas, demais autoridades que aqui estão presentes, e em nome do nosso ilustríssimo senhor Masahiro, cônsul-geral do Japão aqui em Manaus, eu saúdo toda a mesa. Estou representando o nosso diretor da Escola de Direito e, coincidentemente, representando o governador do Estado do Amazonas. Mas, como todos os senhores sabem, o representante não tem poderes. Os poderes são dos representados. Então, é com muita alegria, com muita satisfação, que a gente recebe essa palestra do nosso excelentíssimo senhor Juiz da Corte Internacional de Justiça, que vai nos brindar com seus conhecimentos, com a iniciativa da nossa clínica, aqui da Escola de Direito, coordenada pela professora Silvia Loureiro, Clínica de Direitos Humanos e Direito Ambiental. E, para não estender muito as palavras que a gente quer ouvir, o nosso palestrante, então, mais uma vez, dou minhas boas-vindas, e a universidade, especificamente aqui a Escola do Direito, senhor cônsul, está de braços abertos para outras iniciativas, caso costure acordo. Então, é com muita satisfação que a gente recebe esse evento hoje. Espero que todos tirem proveito desse momento que nós estamos passando, e a palestra traz uma reflexão em que precisamos de conhecimentos, de tolerância e de diálogo para chegarmos à resolução dos conflitos através de acordo. E nada melhor do que iniciarmos conhecendo a legislação que trata, pelo menos inicialmente, nós vamos sair daqui com essas primeiras noções, de uma legislação que nos dê, digamos assim, orientação como chegar à resolução dos conflitos, não mediante a força, mas mediante o diálogo. Então, bom proveito e boa noite a todos e a todas.
Agradecendo as palavras dos membros da mesa, encerramos esse dispositivo e pedimos que os componentes da mesa se dirijam para a frente do palco para a foto oficial e, logo em seguida, tomem seus assentos na plateia para darmos continuidade à programação. Neste momento, convidamos a professora doutora Silvia Maria da Silveira Loureiro para realizar uma homenagem ao juiz Yuji Iwasawa.
Boa noite aos presentes, aos que acompanham a transmissão, prezadas e prezados. The bonds of friendship and cooperation between Brazil and Japan are historic and deep. To symbolize this long-standing relationship, we would like to present you with a work of art made by Mr. Manuel, an artist from the state of Piauí and the municipality of São Raimundo Nonato, where the largest archaeological site with cave paintings in the world is located. As an economic alternative to the local population, the ancient technique of Japanese ceramics was taught, with which this piece was made, guaranteeing the harmony and preservation of the Serra da Capivara National Park. Traduzindo o texto. Os laços de amizade e cooperação entre o Brasil e o Japão são históricos e profundos. Para simbolizar esta longa relação, queremos presenteá-lo com uma obra de arte feita pelo senhor Manuel, artista do estado do Piauí, no município de São Raimundo Nonato, onde se encontra o maior sítio arqueológico com pinturas rupestres do mundo. Como alternativa econômica à população local, foi ensinada a técnica milenar da cerâmica japonesa, em que foi feita esta peça, garantindo a harmonia e preservação do Parque Nacional da Serra da Capivara. Your Honor, thank you very much.
Para darmos início à palestra com o tema Enforcement of International Law, convidamos o juiz Yuji Iwasawa, da Corte Internacional de Justiça. Yuji Iwasawa é membro da Corte Internacional de Justiça. Foi eleito juiz em 2018 e reeleito em 2021. Antes do atual cargo, foi professor de Direito Internacional na Faculdade de Direito da Universidade de Tóquio e também do Departamento de Relações Internacionais da mesma universidade. Já foi professor associado da Faculdade de Direito da Universidade da cidade de Osaka e presidiu ainda o Comitê de Direitos Humanos da Organização das Nações Unidas. É graduado em Direito pela Universidade de Tóquio, mestre pela Faculdade de Direito da Universidade de Harvard e doutor pela Faculdade de Direito da Universidade da Virgínia.
Boa noite, senhoras e senhores. 残念ながらポルトガルはここまでなので、あとは通訳をお願いしたいと思います。
Aqui, então, ele quer dar algumas palavras iniciais em japonês, então eu vou traduzir.
温かいご紹介ありがとうございます。
Gostaria de agradecer a mestre de cerimônia pela apresentação que fez acerca do meu currículo.
通訳をしてくださっている正人二宮先生は、46年前からの付き合いで親しくさせていただいています。
Primeiramente, gostaria de agradecer aqui ao intérprete, professor Masato Ninomiya, que somos amigos há 46 anos.
私のブラジル訪問は今回3回目ですけれども、マナウスは初めて来ました。
Essa é a terceira vez que visito o Brasil, mas primeira vez que venho a Manaus.
アマゾニアの広大な自然を見てとても深く感動しています。
Fiquei absolutamente bem impressionado com a grandeza da Amazônia que vejo pela primeira vez.
私は国際司法裁判所に5年前に、裁判官に就任しましたが、アントニオ・カンサード・トリンダージ判事と数年間一緒にさせていただきました。
Eu fui eleito há 5 anos para ser juiz da Corte Internacional de Justiça, mas desde o início trabalhei junto com o saudoso juiz Antônio Cansado Trindade.
私はカンサード・トリンダージ判事はそれより前からよく知っていて、カンサード・トリンダージ判事も人権の仕事をしてましたし、私も人権のことを仕事をしてましたので、多分30年ぐらい前からよく知っていました。
Apesar de termos trabalhado juntos na Corte Internacional de Justiça, a nossa amizade, nosso relacionamento com o Cansado Trindade remonta a mais de 30 anos, porque, como foi mencionado, o Cansado Trindade era um grande batalhador de direitos humanos e eu também participei da Comissão de Direitos Humanos da ONU e também então trabalhei com ele muito tempo antes mesmo de sermos juiz da Corte.
アントニオと呼ばせてもらいますが、アントニオの、国際法に対する考え方はとてもユニークで、ヒューマナイゼーション、国際法のヒューマナイゼーションということを強く主張していて、私はとても彼のことを尊敬していました。
Como amigo dele, então, nós nos chamamos pelo nome, né? Então, continuarei chamando de Antônio. E o Antônio era um homem grande batalhador pelos direitos humanos e ele falava da humanização dos direitos humanos. E eu comungava precisamente das mesmas ideias dele. Isso realmente nos uniu bastante.
彼の国際司法裁判所に対する貢献および国際法という学問に対する貢献、いずれにとってもものすごく私は彼のことを尊敬していました。
Eu tenho grande respeito pelo meu amigo Antônio, porque ele contribuiu enormemente para o progresso, desenvolvimento do direito internacional público e também desenvolveu enormemente as atividades da Corte Internacional de Justiça.
彼の早すぎる死は国際司法裁判所にとっても国際法という学問にとっても非常に大きな損失だと思います。
O passamento prematuro do Antônio Cansado Trindade foi uma grande perda para a Corte Internacional de Justiça, foi uma grande perda para o direito internacional como um todo e também para a minha pessoa.
彼の後任としてブラジル人のブラント判事が裁判官に就任され、国際司法裁判所に貢献してくださっていることを嬉しく思います。
Como substituto do Antônio Cansado Trindade veio Leonardo Brandt, juiz brasileiro que também hoje trabalha conosco.
今日の講義は、アウトラインがここに示されていますが、私のテキストがポルトガル語で表示されると理解しています。
Bom, aqui vocês estão vendo o resumo em inglês, né, da minha palestra, mas graças aos esforços aqui da professora Silva, então o meu texto completo será projetado em língua portuguesa na tela.
それでは講義に入りたいと思います。
Então vou entrar propriamente no meu texto.
後で質疑の途中まで。
Pedi para descer, mas eles que pedi para eu ficar para atender as perguntas e respostas que virão depois.
それでは講義に入ります。In my lecture today, I will stress that various means of enforcement are available in international law to help secure compliance, and I will examine each of them. Before turning to these various means, I will first address the criticism leveled against international law that it does not qualify as law because it lacks sanctions. Most lawyers consider that sanctions distinguish law from other social norms such as morality and religion. Sanctions in this broad sense refer to coercion applied to members of a community to compel their compliance with the law. In municipal law, violations of criminal law are sanctioned by punishment. In civil law, judgments of courts are enforced by writs of execution. It is often argued that international law is not law because it lacks these kind of sanctions. A well-known scholar who made this argument is John Austin. He argued that law was a command issued by a sovereign backed up by sanctions in the event of non-compliance. As international law lacked sanctions, he considered it to be law, improperly so-called. According to him, international law was mere positive international morality. On the other hand, some lawyers have maintained that international law is law by denying that sanctions are the distinguishing feature of law. For example, Georg Jelinek contended that the distinguishing feature of law was not sanctions, but guarantees. He perceived that sanctions were a mere subcategory of guarantees and argued that international law lacked sanctions but had guarantees. However, most lawyers accept that sanctions are the distinguishing feature of law and argue that international law is law because sanctions are available under international law. It is inappropriate to demand that international law must have the same kind of sanctions as in municipal law, because that approach assumes the municipal law of modern states to be the only possible form of law. In the pre-modern era, municipal law was enforced by self-help. Lawyers have discussed whether international law qualifies as law despite not having the same kind of sanctions as those available in municipal law. It is well known that Hans Kelsen considered international law as law because war and reprisals were available as sanctions under international law. He considered war and reprisals as sanctions of a primitive legal order. From the perspective of contemporary international law, which has outlawed the use of force, it seems odd to regard war and reprisals as sanctions that allow international law to be characterized as law. However, it is true that before the use of force was outlawed, war and reprisals played a certain role as a means of self-help. A notable feature of international law is that self-help is not excluded. Reprisals which do not involve the use of force are permitted as a means to help enforce international law. In addition, various other means of enforcement are available in international law to help ensure compliance. Thus, international law has sanctions in forms different from those available in municipal law. Accordingly, even when one accepts that sanctions are the distinguishing feature of law, one still can affirm the legal nature of international law. In the second part of my lecture, I will explain the various means available in international law to help secure compliance. I will discuss the following 7 means: the domestic implementation and application of international law, the enforcement actions of the UN Security Council, self-help, the law of state responsibility, international dispute settlement, compliance control, and the enforcement of international criminal law through domestic courts and international tribunals. I start with the domestic implementation and application of international law. I consider this to be the most fundamental and important means of enforcing international law. The domestic implementation of international law refers to the enactment of rules by national legislators to fulfill the international obligations of the state. It is the first step needed to give effect to international law domestically. In the following examination, I will focus on the domestic application of international law. In particular, the role of domestic courts in the enforcement of international law. George Russell expounded the theory of dédoublement fonctionnel, or role splitting in international law. According to this theory, national organs play a double role. On the one hand, as organs of a state in its national legal order. On the other hand, as organs of the international community, contributing to the formation, implementation, application, and enforcement of international law. In contrast to executive and legislative organs of states, which tend to prioritize national interests, judicial organs or domestic courts are more likely to serve as true organs of the international community. I skip paragraph 12 and I go to paragraph 13. In respect of domestic application, it should be pointed out that the primary function of a domestic court is to apply international law to the acts of its own governments, and where such acts are inconsistent with international law, to find them unlawful. International law leaves it to states to decide whether it has legal force in the domestic legal order. Custom international law has domestic legal force in many states. Treaties also have domestic legal force in many states, including Japan. However, in a considerable number of states, such as the United Kingdom, treaties have no force of law. If international law has domestic legal force and is directly applicable, domestic courts can apply it and invalidate inconsistent executive acts. Furthermore, the rank held by international law in the domestic legal order is determined by each state. In some states, including in Japan, treaties prevail over statutes, while in other states, statutes enacted after treaty prevail over the treaty. Even when international law is not directly applicable, it can have various other effects in domestic law. In most states, it is an established principle that courts should interpret national laws in conformity with international law. This is referred to as the principle of consistent interpretation or the indirect application of international law. Some constitutions contain explicit provisions on the principle. When legislation is enacted to implement international law domestically, it is evident that it should be interpreted in light of international law. However, the principle should be applied even when national law is enacted prior to the relevant international law. Human rights treaties can be applied to horizontal relations between private individuals. This is the third-party effect of fundamental rights. In Japan, the theory of indirect effect has more support. For example, Japanese courts have used the Racial Discrimination Convention as an aid in the interpretation of the concept of tort in Japanese law. The principle of consistent interpretation can be highly effective, and can contribute significantly to the enforcement of international law domestically. While domestic courts may be reluctant to endorse the direct application of international law, they may be more willing to use international law indirectly for the consistent interpretation of national law. The authority of the international instrument differs according to its legal character. The stronger its legal character, the greater its authority. Domestic courts can also enforce international law externally against foreign states. I have referred to this means of enforcement as the external application of international law. The external application can take different forms. First, victims of violations of international law can sue a foreign state or its officials in domestic courts for compensation. Domestic courts may find that violations have occurred and award compensation. The plaintiff may be a national of the targeted state, the forum state, or even a third state. Litigation of this kind flourished in the United States in the 1980s and in 1990s, beginning with Filartega vs. Peña-Ilala. The U.S. Supreme Court, however, curtailed this trend in subsequent years. Second, on the basis of the universality principle, domestic courts may prosecute and punish non-nationals who have committed certain international crimes abroad. Third, international law may also be applied externally in extraditing or deporting a person to a state where there is a real risk that the person will be subject to irreparable harm, such as an infringement of the right to life and the prohibition of torture or cruel, inhuman, or degrading treatment. Fourth, a domestic court may refuse to apply foreign law and enforce foreign judgments on account of their inconsistency with international law. Domestic courts may do this for the reason that the foreign law or foreign judgment is contrary to the public policy of the forum state, with international law constituting an element of this public policy. I turn next to the enforcement action of the UN Security Council. The Security Council can take enforcement actions which may have the effect of securing compliance with international law. Under the UN Charter, the Security Council can decide to take non-military and military actions, and its decisions bind the UN members. Chapter 7 of the Charter is applied to any threat to the peace, breach of the peace, or act of aggression. Actions taken by the Security Council under Chapter 7 are administrative action of an organ of the UN having a primary responsibility for the maintenance of international peace and security, with a view to restoring peace. However, acts of states that threaten peace or breach the peace are often internationally wrongful acts. Thus, enforcement action of the Security Council signify collective sanctions against those illegal acts and have the effect of restoring legality as well as peace. Thus, enforcement action of the Security Council may serve as a means of enforcing international law. The International Law Commission reserved the term sanction for a reactive measure applied by virtue of a decision taken by an international organization in accordance with its constituent instrument, in particular under Chapter 7 of the UN Charter. And indeed, legal commentators have referred to actions taken by the Security Council under Chapter 7 as UN sanctions. During the Cold War, the Security Council rarely adopted binding decisions to take non-military measures. Before 1989, there were only 2 such cases concerning southern Rhodesia and South Africa. However, Since 1989, the Security Council has adopted numerous decisions to take non-military measures, for example, in relation to Iraq in 1990, Somalia, Libya, Yugoslavia, and Liberia in 1992. The Council often takes non-military measures under Chapter 41 of the Charter in the form of economic sanctions, such as prohibition of the export and import, arms embargo, financial sanctions, prohibition of investment, and freezing of assets. Non-military measures taken by the Security Council also include prohibition of travel, restrictions of cultural exchange, banning the entry of airplanes, and interruption of diplomatic relations. Comprehensive economic sanctions have a significant negative impact on the lives of innocent ordinary citizens in the targeted states. Therefore, since the 1990s, Security Council has started to target specific individuals and entities, including state leaders and terrorists. These sanctions are referred to as smart sanctions or targeted sanctions. Council often establishes a sanction committee to monitor the implementation of sanctions. The sanction committee compiles a list of individuals and entities targeted by the sanctions, which include the freezing of assets and prohibition of travel. The sanction committee have listed some individuals without good basis, and international courts have found violation of the human rights of these individuals. Non-military measures have not only multiplied but diversified. In 1993 and 1994, the Security Council created the ICTY and the ICTR through its resolutions. Article 41 of the Charter formed the legal basis for their establishment. The Security Council has taken a variety of other non-military measures under Article 41, including the establishment of an International Commission of Inquiry, the referral of cases to the ICC, the demand that certain chemical and biological weapons and ballistic missiles be destroyed. While the Security Council is an administrative organ of the UN, it has also exercised legislative functions, adopting general rules concerning terrorism through binding resolutions. I turn to military measures. As the special agreements envisaged under Articles 43 to 47 of the UN Charter have not been concluded, the Security Council is unable to take military measures under Article 42 with binding decisions. Before 1989, there was one instance in which the Council recommended military measures, which was in response to the Korean War in 1950. Since 1990, Security Council has begun the practice of authorizing military actions by member states. An authorization of this nature was first given in relation to the Gulf War in 1990. The Council authorized member states cooperating with Kuwait to use all necessary means to restore international peace and security. And it was understood that all necessary means included military actions carried out by member states. Since then, Security Council has authorized military actions on many occasions. In the Gulf War, this authorization had the purpose of halting Iraq's unlawful use of force. However, the purpose of authorizing military actions has become more diverse since then, including humanitarian assistance, peace building, prevention of genocide, support of fair elections, and protection of civilians. Peacekeeping operations were invented partly because the Security Council was not in a position to take military measures. More than 70 peacekeeping operations have been deployed so far. Peacekeeping operations do not have the function of resolving the relevant dispute, let alone enforcing international law. Nonetheless, they are one of the most successful UN activities. I move on to self-help. A state may resort to non-forcible measures without the authorization of the Security Council in order to induce another state to cease certain conduct. These measures are often referred to as sanctions. However, since they are unilateral actions taken by a state as a means of self-help, some international lawyers avoid referring to them as sanctions. The UN is not the only international organization that applies sanctions, because regional organizations do so as well. Acting under Chapter 7 of the Charter, Security Council has used or authorized a regional organization to implement the Council's enforcement actions. Measures taken by a member state of a regional organization in accordance with such a resolution of the Security Council belong to the type of organized sanctions explained above, because they are taken in accordance with the resolution of the Security Council. African regional organizations have employed autonomous sanctions outside the UN framework on a member state of the organization. Measures taken by member states of a regional organization in accordance with its decision also belong to the kind of organized sanctions explained above, because they are taken in accordance with the constituent instrument of the organization. On the other hand, the European Union has applied autonomous sanctions outside the UN framework on a non-member state of the EU. Restrictive measures that member states of the EU take to implement the decision of the EU are in legal terms similar to unilateral actions taken by states without authorization of the Security Council, because in neither situation can the states rely on a resolution of the Security Council to justify their restrictive measures. I move to retortion. A state may take a non-forcible measure in response to an internationally wrongful act of another state. While the targeted state may regard the measure as unfriendly conduct, the measure may not be inconsistent with any international obligation of the acting state. Where this is the case, the measure is classified as retortion. Examples of retortion include the prohibition of restriction of diplomatic relations or other contacts, and the withdrawal of voluntary aid programs. If a unilateral action of a state qualifies as retortion, it does not raise issues under international law. A state may resort to a non-forcible measure which is contrary to international obligations. However, if the measure qualifies as a countermeasure, it is justified under international law, as its wrongfulness is precluded. International law is different from municipal law in that this kind of self-help is permitted and often used by states. A countermeasure is a measure taken in response to another state's international wrongful act in order to procure its cessation. Under the UN Charter, armed reprisals are prohibited, and since the term reprisals may suggest armed action, it has become common to use the term countermeasures instead to describe this kind of self-help. A countermeasure is an important means of enforcing international law. A non-forcible measure must meet certain conditions to qualify as a countermeasure. First, a countermeasure is only justified in response to a prior internationally wrongful act of another state. Second, a countermeasure must be commensurate with the injury suffered. In other words, it must be proportional to the injury. When assessing the proportionality, it is necessary to consider both the quantitative and qualitative aspects of the injury suffered. The qualitative aspect refers to the gravity of the breach and the importance of the interest safeguarded by the relevant rule. Third, the state must follow certain procedural requirements. For example, the state must call upon the responsible state to fulfill its obligations and notify the responsible state of its decision to take countermeasures and offer negotiations. Moreover, the state must suspend the countermeasure without undue delay once the wrongful act has ceased and the dispute is pending before a court or tribunal which has the authority to make binding decisions. Fourth, countermeasures must not affect certain obligations, including the obligation to refrain from the threat or use of force, obligations for the protection of fundamental human rights, obligations of a humanitarian character prohibiting reprisals, and other obligations under peremptory norms of general international law. The issue which is currently being debated and attracting attention is whether third-party countermeasures are allowed under international law. That is, whether states not injured by an intentionally wrongful act of another state can resort to countermeasures. In 2000, the International Law Commission provisionally took the view that states other than the injured state were entitled to take countermeasures in response to a breach of an obligation erga omnes or an obligation erga omnes partes. However, in view of critical comments submitted by governments, the ILC eventually amended the Articles on State Responsibility. The final articles merely provides that this chapter does not prejudice the right of any state to invoke the responsibility of another state to take lawful measures against that state. ILC explained that it was a saving clause which preserved the position and leave the resolution of the matter to the further development of international law. In the past, it was uncommon for third states to resort to countermeasures. However, since the 1970s, it has become more common for third states to take countermeasures in reaction to serious acts of other states, such as unlawful use of force, flagrant violation of human rights, and denials of the right of self-determination. I now turn to the next means of enforcement available under international law, the law of state responsibility. This law is a set of secondary rules dealing with the consequences of internationally wrongful acts. It has a function of not only providing remedies for violation of the rights of injured states, but also restoring legality through requiring the cessation of wrongful acts. Thus, the law of state responsibility serves as a means of enforcing international law. Since the 19th century, the law of state responsibility has developed through custom. The ILC adopted the Articles on State Responsibility in 2001 after nearly 50 years of intensive work. While the articles are not legally binding as such, many of its provisions are regarded as reflecting customary international law. The state responsible for the internationally wrongful act is under an obligation to cease that act if it is continuing. Cessation was often regarded as part of reparation. However, the Articles on State Responsibility treat cessation as a consequence arising from the state's primary obligations and not part of reparation. Reparation for injuries caused by an intentionally wrongful act takes the form of restitution, compensation, and satisfaction. Restitution means the reestablishment of the situation which existed before a wrongful act was committed. Cessation and restitution thus have the effect of restoring legality. In this way, the law of state responsibility serves as a means of enforcing international law. When a state commits an international wrongful act, another state may invoke the responsibility of that state under the law of state responsibility. If the dispute between these states is not settled by negotiations, they can have recourse to other means of dispute settlement. Thus, the international dispute settlement plays a role in the enforcement of international law. Negotiations are the most fundamental means of dispute settlement in international law. Nevertheless, it is often possible to involve third parties in the settlement of an international dispute. The various means of third-party dispute settlement available in international law are good offices, mediation, inquiry, conciliation, arbitration, and judicial settlement. In international law, adjudication is only possible with the consent of the states concerned. A state cannot initiate judicial proceedings against another state before an international court without the consent of the latter state. The means of dispute settlement that have developed in international law may be classified into non-judicial and judicial means. Non-judicial means include negotiation, good offices, mediation, inquiry, and conciliation. Judicial means include arbitration and judicial settlement. And states have the freedom to choose the means of dispute settlement. International organizations are also engaged in the settlement of international disputes. However, the settlement of disputes by international organizations is not a distinct method of dispute settlement. Rather, international organizations utilize the various means of dispute settlement available under international law. For example, political bodies of international organizations, such as general assemblies and councils, may contribute to the settlement of international disputes by exercising their political influence over the parties to a dispute. This method of dispute settlement may be regarded as a form of mediation. In contrast, independent bodies consisting of individuals like committees or commissions may contribute to the settlement of disputes by utilizing their impartiality and expertise. This method of dispute settlement may be regarded as a form of conciliation. Judicial and non-judicial means of dispute settlement are fundamentally different. Judicial means seek settlement of disputes by applying the law. In contrast, non-judicial means do not limit the applicable standard to the law. In addition, judicial means, decisions of the third party are binding on the disputing parties. In contrast, in non-judicial means, intervention of the third party, such as findings, reports, views, and proposals, do not bind the parties. The parties may reach a mutually satisfactory solution by making use of the intervention of the third party. With respect to international dispute settlement, wide credence is given to the so-called linear track model. This model assumes that the various means of international dispute settlement form a linear track with a list starting with negotiations and is followed by good offices, mediation, inquiry, conciliation, arbitration, and judicial settlement. According to this model, the means which are mentioned later in the list are more desirable, and since judicial settlement appears at the end of the list, it is the best method to settle disputes of all kinds, Nevertheless, this model is inappropriate in the settlement of international disputes. For the effective settlement of international disputes, a multi-track model is pertinent and called for. With respect to legal disputes, in which the states are seeking a solution by way of the proper application of the law, international adjudication is likely the most appropriate means. International courts can apply international law to legal disputes with binding decisions and bring just solutions. ICJ undoubtedly has an important role to play in this regard. However, international law often lags behind societal developments as the international society lacks a formal legislative body. Gaps between law and reality can emerge more frequently in the international sphere than domestic sphere. Such gaps may cause a dispute. For example, where one of the parties is not satisfied with the current state of law and demand that it be changed, international adjudication may not be the best method to settle such disputes, as the party is seeking an amendment, not the application of the law. A more effective method of settling such a dispute is where a third party proposes a fair and equitable solution from the perspectives of justice and equity by means such as mediation. Thus, non-judicial means of dispute settlement plays a more prominent role in international law than in municipal law. I turn next to a means of enforcement called compliance control. It is also referred to as international control or international supervision. It refers to mechanisms whereby international monitoring bodies supervise the implementation of international obligations by states and urge the states to comply with them. These mechanisms have evolved considerably in the international law, and they play a significant role in enforcing international law. Compliance control developed for the enforcement of objective obligations. Reciprocity does not function effectively for such obligations, and compliance cannot be obtained through international dispute settlement, which needs to be initiated by an injured state. Mechanisms of compliance control were devised first in the area of international labor law in 1919. They have since been extended to other areas such as human rights, the environment, the economy, peaceful use of atomic energy, and arms control. Monitoring bodies may consist of either experts serving in their individual capacity or state representatives. Compliance control can be divided into judicial and non-judicial control. Regional human rights courts, the appellate body and the panels of the WTO, and investment arbitral tribunals perform judicial control. In contrast, in non-judicial control, the outcomes are given in non-binding forms, such as reports and recommendations. Compliance control can take several forms. I will examine each in turn. The first form of compliance control is reporting. States may be required by a treaty to submit reports to explain the implementation of the treaty in their respective territories. In 1919, the ILO Constitution established a system of the annual consideration of state reports. The core UN human rights treaties have adopted the reporting system modeled on that of the ILO. The Universal Periodic Review carried out by the Human Rights Council is a kind of a reporting system. Reporting systems have also been adopted by such treaties as those relating to the environment, the economy, and arms control. Monitoring bodies consider reports submitted by states and based on an evaluation of the reports, make recommendations. The second form of compliance control is complaints, and it may be divided into complaints submitted by states and individuals. Monitoring bodies consider complaints and make findings as to whether the respondent state violated its obligations under the treaty. When the monitoring bodies find violations, they urge the states to comply with the obligations. In interstate complaints, a state party of a treaty submits a complaint against another state party, alleging that the latter is not fulfilling its obligations under the treaty. Thus, as a matter of form, an interstate complaint has the appearance of a bilateral dispute settlement. However, as a matter of substance, it has a character of compliance control because the complaining state requests the respondent state to fulfill its obligations under the treaty. And when the monitoring body finds that the complaint has merit, it urges the state to comply with the obligations. Interstate complaints may be divided into judicial and non-judicial procedures. In judicial procedures, a state files a case with the International Court of Tribunal against another state. The European Convention on Human Rights provides for such procedures. The WTO dispute settlement procedures may be classified as judicial control as well, because reports of the WTO appellate body and panels bind the states concerned. The WTO procedures operate as a compliance control mechanism. Maintenance of a free world trade system serves the common interest of the members of the WTO. When one member files a complaint with the WTO, alleging that its benefits are being nullified or impaired, the complaint serves the community interest and has the effect of being brought on behalf of the international community. Contentious proceedings before the ICJ also have an element of judicial control. When a state, other than an injured state, brings a case alleging violation by another state of obligations erga omnes or erga omnes partes. In contrast, interstate communication procedures under the UN human rights treaties may be classified as non-judicial procedures. For example, under the Racial Discrimination Convention, only non-binding recommendations can be made by the Third Committee and the Ad hoc Conciliation Commission, which may be established to deal with an interstate communication. Non-judicial procedures also include complaint procedures in the ILO, interstate communication procedures under the American Convention on Human Rights, and complaint procedures under some disarmament treaties. It is rare for states to submit an interstate complaint except under the WTO agreement and the European Convention on Human Rights. Complaints submitted by individuals also may be divided into judicial and non-judicial procedures. Examples of judicial procedures include individual applications to the European Court of Human Rights and investor-state arbitration. In contrast, individual communication procedures under the UN human rights treaties are a type of non-judicial procedure because views issued by the relevant committees are not legally binding. If a committee finds a violation of the treaty, it not only indicates specific remedies for the individuals, but also often recommends a revision of the law to prevent further violation of the treaty. Non-judicial procedures also include representations made by industrial associations, association of employers or workers in the ILO, complaint procedures before the ILO Committee on Freedom of Association, the complaint procedure of the Human Rights Council, the individual petitions submitted to the Inter-American Commission on Human Rights, and complaints submitted to inspection panels in international financial institutions. We have witnessed a dramatic increase in cases brought before regional human rights courts and investment arbitral tribunals, as well as complaints submitted to non-judicial procedures. The third form of compliance control is fact-finding. It is a procedure by which a monitoring body finds facts and submits the report. Fact-finding may be requested by states or commenced at the initiative of an international organization. It is often used in the area of human rights and includes commission of inquiry established by the Human Rights Council. Fact-finding is also carried out in the context of special procedures in the Human Rights Council and inquiry procedures laid down in some UN human rights treaties. In accordance with the first additional protocol to the Geneva Conventions, a state party may allege a great breach by another state of the Geneva Conventions or the protocol before the International Humanitarian Fact-Finding Commission, a chamber consisting of 7 members undertakes an inquiry. The Commission submits to the parties a report on the findings of fact with recommendations. This procedure may be regarded as an institutionalized form of an inquiry. Well, this procedure has an element of dispute settlement because it may be initiated at the request of a state alleging a breach of another state. It has a character of compliance control because its aim is to monitor the state parties' implementation of their obligations. The fourth form of compliance control is the inspection. It is a procedure by which persons entrusted with this task conduct an on-site visit to verify whether a state's act, facilities, or situations are in compliance with its obligations under a treaty. It is carried out by representatives of either states or international organizations. Mutual inspection by states is set out, for example, in the Antarctic Treaty, the Outer Space Treaty, the Seabed Arms Control Treaty, and some disarmament agreements. The safeguards of the IAEA are a typical example and a good model of inspection administered by an international organization. Some other treaties also utilize the IAEA safeguards as a verification tool, such as the NPT and nuclear weapon free zone treaties. The OPCW, the Organization for the Prohibition of Chemical Weapons, also conducts inspections. In addition to the normal inspection procedure, the Chemical Weapons Convention introduced the challenge inspection procedure. Under that procedure, state party can request an on-site challenge inspection of any facility of another state party. The OPCW then carries out the inspection. Well, this procedure resembles international dispute settlement because the inspection is requested by a state alleging another state's non-compliance, it has the character of compliance control. The fifth form of compliance control is non-compliance procedures set out in many multilateral environmental agreements. This procedure was first introduced by the Montreal Protocol to the Convention for the Protection of the Ozone Layer. While this has served as a model, non-compliance procedures established by multilateral environmental agreements differ in detail. In general, the features of non-compliance procedures may be described as follows. A state party, the Secretariat, or an implementation committee may initiate a non-compliance procedure when there is doubt about a certain state's compliance with the agreement. While implementation committee consists mostly of state representatives, such as in the Montreal Protocol, they may be composed of persons serving in their personal capacity, such as in the Kyoto Protocol. After considering the information and the observations submitted by states concerned and the Secretariat, Implementation Committee reports to the meeting of the parties, including recommendations. The meeting of the parties then may take appropriate measures. Non-compliance with obligations under international environmental law is often caused by a state's lack of financial, administrative, or technical capacities. Therefore, the term non-compliance is used instead of violations for this procedure. The procedure addresses not only violations of a state's obligations under an agreement, but also acts which may not constitute violations of the agreement. Measures taken in response to non-compliance are mostly facilitative and not punitive, consisting of providing advice and assistance. A non-complying state may submit programs designed to achieve full compliance, and the implementation committee monitors its implementation. The meeting of the parties to the Montreal Protocol adopted the following indicative list of measures to be taken. Appropriate assistance, including technical assistance, technology transfer, and financial assistance. Issuing cautions and suspension of specific rights and privileges under the protocol. Enforcement measures are rarely taken. Unlike an adversarial dispute settlement procedure, it is a non-confrontational, mutually supportive mechanism. The unique feature of this procedure is that even a non-complying state itself can initiate it. While the procedure may be triggered by other states, it is rarely required for the complainant state to have been affected by the non-compliance of another state. In other words, the procedure can be triggered by non-injured state. Thus, it is particularly suited for controlling compliance with obligations erga omnes partes contained in multilateral environmental agreements. I move to F, compliance control and dispute settlement. When compliance control takes the form of interstate procedure, it resembles dispute settlement. However, compliance control must be distinguished from dispute settlement. First, their purposes are different. While compliance control has the purpose of ensuring compliance with objective obligations, which are based on the common interest of the community, dispute settlement aims at settling a dispute bilaterally. Secondly, compliance control is not necessarily initiated by an injured state. It may be initiated by a third state, individuals, or monitoring body. In the case of non-compliance procedures, it may even be commenced by the non-complying state itself. On the other hand, dispute settlement is usually commenced by an injured state invoking the international responsibility of another state which has committed an intentionally wrongful act. Thirdly, in general, compliance control is an ex ante procedure, while dispute settlement is one which occurs ex posto. Compliance control aims at preventing violations of international obligations, while dispute settlement is predicated on the existence of a dispute and is initiated after violations have taken place. I turn now to the last means of enforcement of international law, which is the enforcement of international criminal law by domestic courts and international tribunals. Punishment of transnational and international crimes by domestic courts and international tribunals contribute to the enforcement of international criminal law. It has a deterrent effect and helps prevent such crimes from being committed. Crimes are in principle to be punished by domestic courts. For transnational crimes, such as terrorism and slavery, international treaties require the state parties to establish their jurisdiction over the crime so that it may be punished by any party. These treaties also provide for the obligation to extradite and punish. Universal jurisdiction applies to war crimes, crimes of genocide, and crimes against humanity. Any state can try an offender of these crimes no matter where the crime was committed. Some states have exercised universal jurisdiction over these crimes and have tried offenders in their domestic courts. It was truly epoch-making that the International Criminal Court was established in 2003. Its jurisdiction extends over crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. ICC may exercise its jurisdiction if one of the following states have accepted its jurisdiction: the state on the territory of which the crime was committed, or the state of which the accused is a national. The ICC has already dealt with a considerable number of cases. In addition to the ICC, a number of international criminal tribunals have been established. After the Second World War, international criminal tribunals were set up in Nuremberg and Tokyo. In the 1990s, the Security Council established the ICTY and the ICTR. From the 2000s and onwards, a number of mixed or hybrid criminal tribunals have been established. For example, in respect of crimes committed in Timor-Leste, Kosovo, Sierra Leone, Cambodia, Bosnia-Herzegovina, and Lebanon. The Special Court of Sierra Leone and the extraordinary chambers in the courts of Cambodia have many similarities with the international criminal tribunals. I have demonstrated that international law possesses various means of enforcement to help secure compliance. ICJ has an important role to play in the enforcement of international law. However, international adjudication is but one means of enforcement, and it is not necessarily the best way of settling an international dispute. To strengthen compliance with international law, it is necessary to improve each of the means of enforcement and to utilize them appropriately to ensure that states act in conformity with their international obligations. Muito obrigado.
Bom, então quem tiver alguma pergunta, por gentileza, levante a mão, por favor.
Primeiramente, boa noite a todos. Eu gostaria de fazer minha pergunta em inglês. Posso? Mr. Iwasawa, good evening. Thank you for being here. My question is about countermeasure. So you said it's okay. You know what you said. So sorry. Okay, what I wanted to ask is isn't it a means of retaliation